Okay, we're on the record in case D530134, Geraldo versus Gutierrez. State your appearances.
Dr. Kobe's appearing on behalf of the plaintiff, bar number 6460. He's present, Judge.
Good morning, Your Honor. Susan Noyce, Nevada bar number 10833, appearing on behalf of the defendant, who is also present.
Okay, so motion filed by you. We have a
Yeah, it's
opposition.
odd.
Wait, we have a motion filed by you in opposition to. Okay, I see all the filings, but I'm just trying to figure out
I'm not
where
sure
things.
what you've seen as you sit here today, Judge. This is a motion filed by the defendant.
Mm-hmm. But then your motion
Noyce
set for.
does say that she got it to me at the beginning of June. I obviously didn't see it because I filed a motion June 20th.
Mm-hmm.
And then they did an opposition and counter motion to our motion on June 20th. That motion, my motion set for August 23rd. I think it's safe to say that our motion would be treated as an opposition to their motion because it's obviously asking for opposite relief. I just don't think it somehow got linked and put forward, even though the opposition and counter motion got put forward to today's hearing. My motion somehow didn't get put forward to today's hearing, and I'm not sure if you've read my motion. I'm not sure if you've read the opposition.
We briefed it all for today.
So you've seen everything?
Yeah, but I just wanted to make sure that everybody feels like they've gotten an opportunity to respond, reply,
I didn't get a chance to reply to their opposition at this point, Judge. I can argue some things. We have some exigent, kind of emergency surgeon circumstances we have going on right now.
Okay, so go ahead then, and let's let
Mine
Ms.
go first, I
Noyce
guess.
make her argument, and then we'll let you jump in.
Your Honor, as you're aware, we came onto this case after Ms. Gutierrez started the case, so her motion and our opposition should really be considered together, and those would be our arguments. On or about May 23rd, Mr. Geraldo took the youngest child, Alicio, from school, did not return him to school for the remainder of the school year. Ms. Gutierrez has not seen her child since that time. That's what prompted her motion and her order to show cause. At the time she filed it, the child had only been gone for about 3 days, and not everything else had been set forth. So she hasn't seen her child since May. She hasn't really been allowed to talk to her child. Mr. Geraldo will call, but it's at times when she's not available, later in the evening. It's all kind of designed to, I think, keep her from her child. But I think the underlying thing that I want the court to realize here is these parties have been separated for 10 years. And there was some visitation going on starting in 2014 and 2015. Mr. Geraldo finally kind of took an interest in these kids, stepped up a little bit, and had an ongoing relationship with them. And then starting last August, she was moving to California. He knew about that. He decided to keep the daughter. Then it's all kind of fallen apart since then. His wife and her mother show up at her work, her partner's work, her house. It's just completely gone south. Then we have some other issues. One is that he went to the daughter's school to try and take the daughter from the school. He was searched by police and found to have Mr. Procopius tells me, a pocket knife on him. He is now being criminally prosecuted for bringing a weapon on school grounds, but he never should have gone to the school to get the daughter and take her away in the first place. We also believe that he has just completed a heroin detox in or about May. So all of this is very concerning to us. Not only is he keeping the child, he's keeping the child from her, but he is he's got some baggage and things in the background that we're having a hard time with this man on the co-parenting level. We understand there are some health issues that Mr. Procopius will outline regarding the little boy. He has a hereditary bladder condition. He now seems to have some type of a bowel condition as well. He is seeking medical treatment for it and is on a strict diet, and of course Mr. Procopius can tell you more about that. We see no reason why Ms. Gutierrez cannot pick up the ball on that one and continue with the treatment and follow the doctor's instructions and have this little boy back to where he has been living for the last 10 years. We believe part of his constipation and bowel problems may be due to stress and a new diet and all of that. So we don't want that discounted. They've also asked for a child interview of the older daughter. We're perfectly in agreement with that.
Okay.
Judge, this has kind of gotten into a very, it's kind of taken on a life of its own, this case. It's kind of blown up pretty quickly. It all started in basically in October when the defendant decided she was going to move to California with the children. My client clearly sent a text saying, you don't have my permission to leave. But she left anyway. And at that point, even after she came back to Nevada, at that point, my client's contact with his children has been severely limited, if not eliminated completely. Basically, for between that time she left and the time that my client went to the school and picked up the youngest son, he had basically no contact with either one of his children. He had came to me way before, and she had left, and I didn't have an address. I had nothing to be able to serve her with in California. So my client did take it upon himself. I mean, he has equal rights to his children. He did go to the school on May 23rd and picked up his son. Had the son in the emergency room by May 26th. This son is under a very strict doctor's regimen at this point because he's moderately to severely impacted in his colon. I actually have the X-ray in the car, and it's kind of disturbing and it's hard. You can't say from May 23rd to May 26th when he first went to the child to the emergency room that's what. This is a build-up situation. This child is still not properly going to the bathroom. And the doctor's actually concerned at this point. I did show the records in talking to my clients. The doctor's actually concerned at this point that they're going to have to go in and possibly do some serious surgery in this situation if things don't clear up soon. The urology issue is a separate issue. It is a hereditary issue as an overactive bladder, and he's on medication. And my client's taken the child to them. So since May 23rd, there's been 5 doctor visits, and there's another follow-up, and there's strict diet, strict regimen of medications, et cetera, et cetera. So as far as the son is concerned, what we're concerned about right now is we don't want to. My client's been the one that's been at the doctor's appointments, at those issues, and has followed the doctor's recommendations and regimen as to what to do from here. We don't want to upset that right now because what will happen is if you take the child and put it back with the child hidden back with the mother, now dad has to educate mom as to what's going on, and then what's going to happen secondarily is mom works and leaves child with grandma, and now dad's going to have to educate mom, mom's going to have to educate grandma, and now we're talking about 3 times removed of what's going on with the medical treatment of this child, when right now my client's current wife is a stay-at-home mom and can very clearly regiment what has to happen to hopefully keep this child from having to have surgeries. And they're talking, if it goes to that point, it could be a situation where a part of his bowel is removed. And that's not good for a child of this age, obviously. So and I'll address the other issues, Judge. They're spinning things a little bit. Okay, he was not in for heroin. He was in a car accident in 2013. He was prescribed medications. You've heard this story, I'm sure, many times in this situation. What happens is the pain doctors keep you going on all the medications because they keep getting their money every month. And my client finally said, you know what? I'm done. I don't want to be on this stuff anymore. And voluntarily went in to a detox to get himself off of these pain medications in, when was it?
It was
February?
May.
May. Okay? Now, the interesting thing is they wouldn't even know about this stuff if her mother didn't go in and illegally get the treatment records. And I have a letter from Sunrise saying that she's been properly disciplined for going in and getting the records that they weren't even entitled to. But what am I supposed to do? I can't come to court saying that's not true because they illegally obtained medical records of my client without HIPAA. Okay, but this is the kind of thing we're dealing with here. But my client would be happy to drug test today. He is on Suboxone, which is, I'm sure you know what that is. That's the only thing that would be positive in his system today. If you want him to drug test today, he will. If he comes back positive for any opiates, etc., I think he he understands. I mean, other than Suboxone, which is the detox drug. As far as the going to the school, he did go to the school to pick up. I don't remember exactly why he was at the school. But the cops were called because I think he did have a child support issue going on. They stopped. They when they were going to arrest him for that, he had a pocket knife in his pocket. He didn't ever pull out it was, you know what, he works in what do you work in a warehouse, right? Construction. He had a pocket knife in his pocket, and they said you weren't allowed to bring that on school grounds. So that's, I mean, they thought it was a gun. I mean, that's not the case. It was a pocket knife, Judge. So I think that doesn't necessarily mean he can't do that. So what we're asking for, Your Honor, right now is this. I'd like you to see on a temporary basis to say, let the son stay with my client. Do it without prejudice. Do it on a temporary basis. These charge parties already tried to go to mediation. It didn't work. Do it on a temporary basis. My client has a DA case. We can deal with child support inside the district attorney's case at this moment. Mm-hmm. Let mom keep the daughter, have the daughter interviewed, and then have them swap the children on weekends so that the two children are together at dad's house and two children are together at mom's house. I just want this as a temporary measure. We can go into a trial and we can do all of what needs to be done on witnesses and testimony and exhibits and everything we need to prove what's in the best interest of the children moving forward. However, due to this exigent circumstance with the son and my concern about the consistency of care right now, I really think it would be best for this child to stay with my client, at least for the next few months, to get this situation taken care of with his bowel. It's scary. I mean, he's now been on Miralax and on a strict diet for a month or more, and he's still not properly going. So he's due to go back to the gastroenterologist on August 9th, I believe, for a follow-up, and they're going to know more. There was more labs that were ordered and everything else. So it's just something that I think consistency right now is going to be important for this son on a temporary basis, Judge.
Just a couple things, Your Honor. First off, she didn't have his medical records. That's why I want the HIPAA. I want to see exactly what he was in the detox for. We believed it was heroin. If we're wrong, we're wrong. But I would like a HIPAA to see what he was there for. The other thing is, Your Honor, while the little boy's condition may be severe and ongoing, I still think there's an element of stress in being taken from his home where he'd lived for the last 10 years and subjected to new home, new diet, new everything. And if he's to
But he
stay
was in the
there,
emergency room within 3 days with this
Yes.
issue, so that sounds to me like
he
it
can go to an
happened before
emergency
that.
room.
Pardon?
He can go to an emergency room for anything. What I'm saying is, it may not have been a true emergency. It may just been the choice of forum at that point. What I'm saying is, I think she's perfectly capable of following medical care as well. And it raises the other question: if he's with the plaintiff for the next few months, are they planning on changing his school? Is he now going to have to adjust to a new school? He's got to adjust to a new home life without his mom and his sister, who he's lived with all his life. Does he now have to adjust to a new school? I think stress is a big factor here that also needs to be looked at.
What's her work schedule again?
She works 3 days a week. She's perfectly capable.
Which 3 days?
Which 3 days do you work?
Thursday, Friday, Saturday.
And the 12-hour shifts?
No.
What are they?
I have 4, 6, and then I think on Friday or Saturday it's either 8.
4, 6, or an 8?
Mm-hmm. It kind of fluctuates.
The other issue we have, Your Honor, is, there is a child support case. He was due in child support court yesterday. He didn't show up. This is the 5th contempt of court for his failure to pay. This all really started and took off once we understand, once child support really came after him and seized a tax refund. So, again, I understand the little boy has a medical condition that needs to be looked at. there's no evidence that she's ever been neglectful or that she's incapable of doing that. But again, you have a little boy who lived with her for the last 10 years, not with him. And I think stress and a new home environment has a lot to do with this as well.
I mean, you can think all you want, but there's no evidence, no medical records.
Right.
say anything.
I'm not saying that that's
Or
the
there
case.
is the other direction either.
All we know is within 3 days, he was in the emergency room and was referred to specialists from the emergency room immediately. So,
Okay, so she's off on Sunday, Monday, Tuesday, Wednesday. And when's your client work?
you're off weekends?
No, I work 7 on, 7 off.
7 on, 7 off?
He has an intact family unit in his house as well, though, Judge. He has a wife, he has a new child, and 2 other children. So they have a family structure, and the wife is a stay-at-home mom right now, too. So I'm just saying there is care even when he works 7 days. So.
Okay. Because obviously, I mean, I can't say that she's not capable if she's home. I mean, she's going to need to learn whatever care the child needs at some point whenever the child starts spending time in her home again, which should happen. I mean, I think that should start. He needs to teach her that whatever's happening.
Right, and that's been a problem. Their communication level and their co-parenting level has...
Well, they're going to need to do it because they have a sick child.
Right.
Clearly, that's going to have to happen. You're going to put yourselves aside, your dislike for one another aside, your lack of communication aside, and you're going to do what you need to do to take care of your son. Because otherwise, he's the one that suffers. For what? So, I'm going to say that
It seems that the weekend thing would probably be best.
you're talking about the daughter staying and then alternating the weekends. Basically, yeah. I'm trying to. The problem is she works Thursday, Friday, Saturday. So
I understand.
it sounds in theory good, but then she's really never home during the time the children are with her, or you know what I'm saying.
Right.
So what I was thinking was. Instead, splitting the week, allowing Dad to have Thursday, Friday, Saturday, Sunday, overnight, 4 days, and 3 days with Mom. The days she's off.
So from Thursday to Sunday with
Monday,
Dad?
Monday,
Or Thursday to
Monday
Monday with
morning
Dad.
to Thursday morning. That's 3 days. Monday overnight, Tuesday overnight, Wednesday overnight. And then Dad having the 4 days, because that's during her time plus a little, during her time at work plus a little more. So it'd be 4 days with, the problem is we have one that's not going over there.
That's the problem. My client hasn't seen his daughter in barely since October. Once or twice. Since
Okay,
October.
so here's what I'm going to say. Look, I'm not going to micromanage them at this point. I'm going to make that the order
For both?
for both.
Okay.
However, I'm going to have her interviewed.
Mhm.
And I'm going to say that they probably need to do some reunification visits, spend some time together. Maybe your job is to encourage her to go, and your job is to understand she may not be keen on the idea of the full period of time right now, but you're going to work toward expanding that time. I mean, she's 13. It's not really up to her, but at the same time, you can't drag her kicking and screaming. I get it. So your job is to, and if we need to send these, if they need to ultimately do some type of therapy, I don't know if they have the ability or the wherewithal to do that, but that's an option. But let's hear from her first. Let's get an interview, because she may be keen on it. Your position is, hey, look, she really does want to be over there, but she's
Right.
being threatened to not go over there, therefore
Right.
she's not coming.
Right.
Well, if that's the case and that's what I learned, I'm not going to be happy about it. So I think you're probably behooves you to make sure to put that issue to rest by ensuring that she goes. Okay. So my order will be Thursday to Monday. So I'll say Thursday 9 a.m. to Monday 9 a.m. If they start school, then it's Monday. It's drop off at school. Thursday, right?
Thursday
So
pick up from school.
right.
Right.
Well, the time starts. He's obligated as of Thursday when the kids go to school.
Got it.
So Thursday morning to Monday morning, 9 a.m. or school drop off. Mom's time will be Monday morning to Thursday morning. It's a joint custody scenario. We'll have the daughter interviewed. And Dad's obligation now is to teach Mom all the medical things that need to be known about their son, that he's, got on board, that he's been following, so that she can follow it those 3 days. And the idea is consistency. So whatever he's doing that the doctor's been teaching him, you want to make sure you implement at your house so that everybody's doing the same thing, so that he's not all over the place, because it's just going to cause him more medical problems. So we'll defer to the our case for the child support at this point.
Your Honor, do we have a pickup, drop-off location?
Yeah, for now, where will we do the exchange?
Well, can you pick up from her?
Yeah, as long.
We can do honk and seatbelt rule and pick up from receiving party picks up.
Okay, I don't think she knows where he lives because the last text message we saw said he moved.
She does know.
She knows where it is.
Okay, so what's your address?
Let's put it on the record.
They're
Let's put it
moving
on the
in
record.
They're moving in 2 weeks. They're still
Okay, so
where
what's your address now? What will your address be in 2 weeks? Let's put it on the record. Do you know?
3355 Wasatch Cedars.
is your address now?
Currently. And then what will be the new address?
We have yet to get a new place yet.
Okay,
we're still,
so,
we're still looking.
You're going to need to make sure you notify her
Upon a
obviously
change.
immediately,
No
as soon as you
problem.
know what it is. I'm going to order the parties use talking parents so that they can communicate regarding their children, transmit all their information through this program. So it's free, so they don't have to worry about paying like the other one that we utilize typically. And so if you can give them the talking parents order.
Do you want a return date?
Yeah, we're going to have a return date on the interview.
60 days?
Yeah. Is that typically how long it takes? Is that what they are wanting us to try 45 days?
45. So the return date's going to be August 31st at 2 p.m. Do you want standard questions?
Standard questions. Does council have any questions they want asked specifically?
I mean, I don't. My client says she's very afraid of.
So here's what I'm going to ask you to do. If there are any specific questions that you have that you want asked of the child, within by next Friday, both council is entitled to submit to Chambers 5 questions, and then we'll submit them to FMC. If I don't get any from you, then they'll just ask the standard questions. How's that?
Got it.
Okay. So anything else that we need to deal with?
We have our HIPAA release.
Well, that's a discovery issue. I mean, you need to.
But I can't get it without a HIPAA release.
I'm sorry.
I can't get those medical records without a HIPAA release.
So have you submitted one to council through a discovery request?
That's why we put it as part of our opposition rather than go through an entire discovery. Just make it a part of a request of our motion or our
I mean,
opposition.
I would say I don't know
We
what
don't
your
have a trial
HIPAA
date
release
set
is
yet.
asking for. Pardon me.
We don't have a trial date.
We're going to set
yet
one.
or
We're going to set
anything.
one right now. This is
Okay.
the early. This is the case conference also. I'm not going to order just a blanket HIPAA release because I don't.
I think we specified in our opposition we want one for Sunset Hospital for the period of May 2016.
Just May 2016. Okay, let me look here.
Yeah.
All right.
I think we were fairly.
It really, really bothers me that this is like fruit from a poisonous tree at this point. But
And
I
once
understand
you
that we're
learn-
dealing with it.
right. You don't have a proposed one here attached, do you? I'm not going to order. Ms. Noyce, I'm going to say, submit one to Mr. Procopius that is one that's limited. that is seeking whatever the information is that you're seeking, if do it through a discovery request. If there's an issue or they won't sign it, or there's some discovery issue, at that point we can deal with it at the return. But I want to see what exactly it is that you're looking for. I just feel very uncomfortable ordering HIPAA release and then someone's in violation because they're not signing it, because it's looking for more than maybe, or you might obtain information that really isn't relevant, and I want to make sure you hone it to exactly, just being very specific, okay? I mean, HIPAA's there for a reason, and I understand for purposes of a custody action, we're entitled to the information regarding his drug issues, but I would ask that you submit that to Mr. Procopius first, and Mr. Procopius, I would recommend that you get her that information.
Understand, Judge.
But that it be, like I said, I don't want him to
Limited.
have to reveal everything that he's
Sure.
got going on if it's not relevant to that particular issue. I don't know what that release will ultimately yield, is my point. So, okay, so that'll be my issue, and then that'll be my order. And then if, like I said, there's an issue on our return date, we can deal with it, Ms. Noyce, and we can.
You want to
At
set
that point, what I would do, I'm sorry, if you have a dispute over the HIPAA release, would you submit to me a supplement so that I know what the issue is? Okay.
and then we'll set a trial date?
Yes, we're doing that right now.
Half day or full?
Half day or full day? This is just going to be on custody first.
I gave up trying to guess how long these are going to go because they tend to
I
go.
think it should be a half day, Judge.
Half days are being set out about 5.5 months.
Hey,
It's gonna be January 5th.
Really? Because guess what? Y'all come in here, oh, I'm not ready, I haven't finished, we're not prepared for trial.
That's
And
because you set them out so far that we just forget about them.
I've been sitting, I've sat in your seat a lot of years. I know that's,
9 a.m.
that is so not true. If I were to set it in 90 days, you'd be crying. No, it's not when nobody's ready.
I'm joking, Judge. But,
Okay.
and then, are you going to do like a scheduling order with the cutoffs and everything else, or do you want?
Well, you know what? Since you're preparing, we're going to prepare an order. Who's going to prepare from today?
I'll prepare.
Okay, we'll just have you include those dates in the. So it's going to be give them the 30-day prior date. So 30 days prior. Use your little calendar over here. So 30 days prior to trial is discovery cutoff. Hold on one second. What was the trial date?
January 5th.
Okay, so December 5th will be discovery cutoff. I think that's a Monday. December 14th will be when your pretrial memos will be due. And exhibits and witnesses are due 1 week prior to trial.
Do you want us to name witnesses at the before the discovery cutoff?
Yeah, absolutely. But you're going to have to do that in the requisite time period. But the witness list and the exhibits are going to be due to the court 1 week prior.
All right.
Okay.
Your Honor, as I understand it, if she's to have the children Monday through Thursday, today's Wednesday, can she go pick up the little boy today?
Can't we just? I mean, we're not going
Why
to
should she have to wait
for
till
one
Monday?
day, and then back tomorrow, and then
Hold on.
you might as well do it Monday.
She hasn't seen him.
I understand. We have medical stuff we need to deal with too, right? What's
Yes.
happening right now in terms of, you're going to have to communicate that information. Do you have the talking parents?
Yes.
Let's start it on Monday. I'm sorry, Ms. Noyce, but I think she needs to communicate with him what's going on. What does she need to get in her house? What is are there meds? Is there food? So you need to communicate all of that to her, and then on Monday we'll start fresh. That'll be the order. I just think that's better than bouncing him back for like 18 hours back and forth. Is there a way you can do an evening visit tonight where she has some time with him for dinner or something?
Yeah, that's fine. I just hope she doesn't try and upset him intentionally.
Well, I don't know. That's a different story altogether. If you're making the argument that it's his medical issues, that she needs to understand all that, I don't know what all the parameters are there, but she's going to start seeing him Monday through Thursday, So
Perfectly fine.
let's say today she can pick up, what time, you don't work today, right? So let's say you pick up at 4 and have him back by 7. Just take him out for dinner, something, and then that way you can get this ball rolling and you'll have him back on Monday morning at 9. By then he'll have communicated to you everything that you need to
Why don't
know.
they swap tonight and he can have dinner with his daughter too?
I leave my house at 5. I
I
work.
don't have a problem with
You
that.
work tonight?
Let's
No,
swap
you
the
can't- you
kids.
can't do
How's
it
that?
tonight. He can't do it. He leaves the house at 5 o'clock tonight, so for work.
I work graveyard. 12 hours.
Okay, well then you can't do it. All right. So
All right.
bottom line is, those are my orders. Tonight she can have from 4 to 7, and then on Monday she'll start her schedule. I have to let everybody go. That'll be my order. Mr. Procopius, you're in charge of preparing. Ms.
Very
Mills
good.
will sign off.
Thank you, Judge.
Thank you.